So welcome everyone. This workshop is on what to do after someone dies. Because today's workshop is recorded, I do have to say a quick little disclaimer for the recording. This workshop is held on June 5th, 2026. The workshop is recorded. Educaloi grants access to view this video recording for a limited period of time. Access is limited to ensure the legal accuracy of the workshop information, since the law can and does change over time. Updated, complimentary, and reliable legal resources are available on our website at educaloi.qc.ca. The workshop is divided into 4 parts. We'll be looking at 3 things to prioritize in the event of death. Then we'll look at what to do after searching for a will. We'll move on to the steps in settling an estate, what the liquidator has to do. And then the last section will be about frequently asked questions. So we'll look at 3 different scenarios, I believe, or 4, and frequently asked questions in those types of scenarios. So to kick off the workshop and get a sense of the group's understanding of the topic, here's a question for you, and you can, again, answer in the chat. In just a few words, what does estate mean to you? What do you think this means? So we mentioned, we talk about settling an estate earlier. So I just kind of maybe want to see if anyone knows what that means, if they have an idea of what it could mean. And maybe another term that you have heard in Quebec, an estate is legally called a succession. So you might have heard of that term instead. So what does estate or succession mean? Someone answered overall assets. Yeah, that's a great place to start. Someone else answered settling my affairs and implementing the deceased person's wishes. All your assets, belongings, everything left behind, assets, debts as well, another word that came up. So all very good answers there. So let's move on for now to see what the official definition is. So the term estate or succession in Quebec is used to refer to all of the deceased money and property. So settling an estate means transferring the money, property, rights, and also the debts, as someone mentioned, of the deceased to one or more living people. This transfer is made to the people identified in the person's will, or if they don't have a will, to the people the law says can inherit when there is no will. So those are the heirs. The rules I will be talking about today apply to situations where the deceased lived in Quebec and all of their money and property are located in Quebec. So these rules still apply even if the person died abroad, as long as their home, their primary residence, was in Quebec. These rules also apply to people who are not Canadian citizens. So if when they die, their home is in Quebec as well. So here we're talking about, permanent residents or temporary workers whose home is in Quebec. Before we move on, can anyone name different people involved in settling an estate? So you can write your guesses again in the chat. You can name, individuals or even services provided in connection with estates. So we'll be looking at 6 on the following slide, but I just wanted to see if there are any that already come to mind before presenting them. Someone already answered liquidator, which is a great answer there. The executor, yeah, that's another word that we hear that refers to the liquidator, actually. So someone else answered liquidator, notary, heirs, executor, creditors, notaries, lawyers. Lots of different answers there. And as we'll see, they are all right. So let's first look at the people who are involved in most estates. So the first answer that popped out, actually, the liquidator. So the liquidator was previously known as the executor or the testamentary executor. Those are the old terms we used to refer the liquidator by, but right now the term in the law and that is used by the government officials on their website is the term liquidator. So the liquidator is the person responsible for settling the affairs of the deceased. So for example, they generally have to make a list, so an inventory of the deceased's property, and they also take care of their taxes, paying their debts. So they do quite a bit of things here when settling an estate. So we'll look closer at their role later on in the workshop. The next people involved, the heirs, who were also mentioned in the chat earlier. So the heirs are the people who have the right to inherit and who accept the inheritance. So when we talk about the heirs legally, if someone has refused an inheritance, then they are no longer an heir. And then last person here, Married spouses, or specifically partners in a parental union, have a special status since death means the end of the marriage or of the parental union. So the couple's property or the family's property must first be shared between them to determine which property is part of the estate to be distributed to the heirs. In some cases, a married spouse and the children of the deceased can also have a right to claim spousal or child support from the estate, so alimony or child support. This special status that applies to, again, married spouses or parental union partners does not actually apply to common law partners who are not in a parental union. So that's something to keep in mind when we're talking about the spouse or the partner here. We're really referring to married spouse or parental union partner. And just because it is kind of new, I'm just going to explain parental union really quickly. So it is a new type of union that exists only since last year, actually, June 2025, so about a year from now ago, sorry. So non-married couples that have a child born or adopted after June 2025 are automatically in a parental union. So they are common law partners that have a child together or who adopt a child together. And that child must have been born or adopted after June 2025. So those are parental union partners. So next, we'll also look at three services that are provided in connection with estates. So the first one that we're looking at, funeral services. So these services are offered by funeral homes, and these services handle, the funeral arrangements, and they can also sometimes guide you through the first steps to be taken. Someone also mentioned lawyer, notary, and very important professional here. They can help you settle the estate and perform certain tasks for you as liquidator. So a notary specializes in agreements and must remain neutral towards everyone involved. As for the lawyer, they are the specialist that can really help you in this if the situation escalates and turns into a conflict. So, for example, if the heirs don't agree amongst themselves what to do, or if the heirs don't agree with what the liquidator is doing, it is possible to involve a lawyer, go to court, and have the issue settled. And the last one here that we're looking at, the accountant. So an accountant can analyze any tax and financial impacts resulting from the transfer of the deceased's property, and they can also prepare the income tax returns that must be filed when someone dies. So these are the people involved in most estates. So just so that we kind of know what these people refer to, these terms refer to when I'll be referring to them in the rest of the workshop. So this was our fairly long introduction. So let's dive into our first subject. So 3 things to prioritize in the event of death. Before you can really begin to settle the estate, transfer property, etc., there are a few preliminary steps to take. So after telling the family and loved ones, you do have to notify the government of the death and get a proof of death. I believe someone asked a question even before the workshop started, how do I get a certificate of death? So that is something we will cover. You also want to organize the funeral and then check if there is a will or even many wills. So these steps can be taken by anyone who believes they are an heir, or otherwise it can be taken by the spouse or even the liquidator if there's already a copy of a will naming a liquidator that we know of. So this can be really taken by quite a few different people. So it's not a role that is specific to a certain actor in settling an estate here. If possible, it is best to coordinate before taking action to avoid repeating tasks, just because since these tasks can be done by many different people, many people might try to get things started without really discussing things. So you don't want to repeat steps. So do talk about it with the people around you, the loved ones of the deceased, to coordinate. And one other mention here is that these steps do not need to be taken in any specific order. So they can overlap, or you can do, the last one first, second one, second, etc. So it really doesn't matter what order you do these steps in. So let's look at each of these steps more in detail. So let's start with notifying the government of the death. So the death must be recorded in the Register of Civil Status to be recognized by the government. Otherwise, you won't be able to get the official proof of death needed to settle the person's affairs. So this is really an important step to go through. For the death to be recorded in the register, a declaration of death must be sent to the Directeur de l'État civil, which is Quebec's Registrar of Civil Status. The declaration of death is a document that is completed by the funeral home and someone who is close to the deceased. So they fill this out together. The funeral director will take care of generally giving the document to the deceased's loved ones. And when the document is filled out by the family members, the loved ones, it's really the funeral home who will send the declaration to the Directeur de l'État civil as well for you. In addition to the declaration of death, you can complete the application for the simplified forwarding of information relative to the death to the departments and agencies form. So quite a long name there for a form, but in short, it's really to fill it out so that government services will be automatically notified of the death of your loved one. So this form is generally sent to the loved ones with the declaration of death. So it's really, again, the funeral director that will be able to let you know where to find the form if you don't find it in your papers. So once a declaration of death has been sent to the Directeur de l'État civil, the liquidator or a loved one can order a death certificate or a copy of an act of death through the Directeur de l'État civil's website by mail or in person at a Service Quebec office. So they can also ask the funeral home or their notary, lawyer to help them order these documents. But in this case, there may be additional fees to pay just because a professional is helping you and taking, measures, steps to order these documents. You will need this proof of death, so either a death certificate or a copy of an act of death made by the Directeur de l'État civil to check for a will and settle the estate. So again, important step here. So for example, you might need these documents to put an end to different services like pension plans or close bank accounts. One thing to note is that it does take some time to get a copy of an act of death or the death certificate. So this often takes several weeks. It is important to get started on requesting these documents as soon as possible. Now, another preliminary step to prioritize is organizing the funeral. So the funeral is based on the deceased's last wishes. And these last wishes can come from a prearranged funeral contract, for example. So if the deceased made such a contract with a funeral home, it will be registered in the Registry of Funeral Prearrangements. So you can ask the funeral or burial service provider that you're doing business with to do this search for you. It is free and they get the results instantly in their file. So you can ask them at any time. The will or another document prepared by the deceased is another place where you might find last wishes. So again, here, if you have a copy or if you know where to look in their papers, it is another place where you can check to see if any last wishes were mentioned. And finally, if none of the documents say anything or there are no such documents available, maybe there were verbal instructions given by the deceased to family or loved ones. So you can ask around to see if someone had this type of discussion with the person beforehand and if there were some wishes that were expressed in the past. If the deceased did not communicate their last wishes in any way, so they haven't really talked about it, they didn't note it down in any document, then the decision regarding the funeral is made by the people who can inherit. So anyone who could potentially be an heir has a right to discuss this and determine what they want to do with the funeral. And now we move on to the third thing to prioritize, which is checking for a will or several wills to make sure that you have the latest one. So a will is a document that expresses the wishes of the person who died. So it can say who will inherit their money and property. So that's generally what most people know wills for. But a will can actually also name a liquidator to settle the deceased's affairs. It could specify the powers of the liquidator in settling an estate. So, for example, the liquidator could be given the power to sell property without having to ask for court permission. So, a house, a building, they normally, without this power written in a will, the liquidator does have to request the court's permission to sell these buildings. Next, in a will, you can actually also reduce the amount of income tax payable by leaving, registered retirement money to the deceased spouse. So there is a way to make sure you pay less taxes or you push back taxes paid in your will. So these are different strategies when planning ahead, and a lot more as well. So what you want to do to check for a will is check if there is a will listed in the will registries. So in Quebec, there are two will registries or registers. So there's the registry of the Chambre des Notaires, the Notaries Association, and also the registry of the Barreau du Québec. So that's the Quebec Bar. So while the registers are independent, it is possible to search both at the same time by submitting one centralized request using the single portal registry service for wills and protection mandates. It's quite a long name here. Don't worry. Again, you can find this information with handy links on Educaloi's website. So you can do the search yourself by completing the appropriate forms on the portal's website. Or again, you can always pay a notary or a lawyer to help do the search for you. They could actually even get results faster in some cases. Now, you'll also want to check the deceased's personal papers, just because, again, wills don't necessarily have to be drafted with the help of a professional. They don't have to be notarized. There are different types of wills. So it's possible that the deceased's personal papers have what we call, say, a holograph will, which is a will completely written by hand, signed by hand, so without the help of a professional. So you do want to check through their papers to make sure that this type of will doesn't exist or exists. So this kind of will is not normally listed in the will registries, though they could be if the deceased went to a professional to get them listed. But this is something to be aware of, and you do want to search through the will registries and also look through their personal papers. So this was a lot of information in very little time, but we are at our first question period.
I have about two or three we can start off with as
Perfect.
people are writing. So the first one, is there a certain number of death certificates we should request from the funeral home?
So it does depend on the situation. So I can't quite answer for sure. There's no one right number. It depends, for example, on what kind of assets or what kind of account services the deceased had prior to passing. Yeah, so death certificate is not it's not the director of the funeral home who gives it to you. It is the directeur de l'état civil. So again, the funeral home could help you with the steps, but you do get the copies from the directeur de l'état civil, so the registrar of civil status.
A next one that just popped in the chat is a deceased personal will, non-registered, legal, and how is it handled compared to notarized?
So we will actually be looking at that in the next section part two. So after searching for a will, but in short, there are three different types of wills that you can make. The first one is the notarized will. The second one is a will before two witnesses. And the last one is the holograph will, which I just explained, which is the one where you fully write it by hand, sign it by hand, and it doesn't have to follow any, specific formalities. As long as it's written by hand and signed by hand by the person whose will it is, then it is a valid will.
So why would we need a death certificate versus a copy of active death?
That's a great question. So the difference here is that the copy of act of death is a lot more detailed. So it really depends on the institutions that you're trying to close these services with or the accounts with. So some institutions will really want the copy of act of death. Others will just need the death certificate, which is, again, less detailed. So it does help preserve confidentiality of certain information. So it really depends on the institution that you're dealing with.
Okay, and we often hear about a $2,500 funeral payment from the Quebec government. What is this?
So part of the funeral can be reimbursed by the Quebec pension plan if the deceased contributed enough to this plan while they were living. So this is called a death benefit, and you can look it up online to find it on the Quebec pension plan's website. So it will be up to $2,500 reimbursed to cover the costs of the funeral. Now, if the person had prearranged funeral contracts where they already paid for their own funeral services, then the heirs can still request this money. It won't necessarily go to reimburse the funerals since the funeral was already paid for, but it would simply go back to paying the heirs for other things. So it is possible for the heirs to request this sum of money.
And any thoughts on having a liquidator living outside Quebec?
Great question as well. We will be looking at that in part three. So when we were naming a liquidator, what type of things we should think about. It is possible to name a liquidator living outside of Quebec. It's not always the simplest option, just because again, the liquidator has to do a lot of things in Quebec to close accounts, to sign papers, etc. So if someone is living outside Quebec, it might be a little, they might have to fly back and forth. It might be a little more complicated, but it is possible. So it really depends on, who's around the deceased, who do you trust to take care of your affairs after your death. There's no one right person or to name as liquidator. It really depends on the situation.
If I plan to pay for my own funeral, can I request this payment now?
I don't believe so. It really is after the funeral. So we do look at I believe there are certain documents that are only either the copy of death certificate or a copy of act of death that is required to get this payment. So it wouldn't be possible to request the amount before the death.
That was marvelous interaction, and you can see that people are really have lots of things and items to dot the I's and cross the T's and are interested and concerned about. And no doubt we're going to get more information as we move right along into the next session, which is after searching for a will. What's our next steps?
So we're now at our second section on what to do after searching for a will. So we will be looking at this section with a scenario. So here's your scenario for this part of the workshop. George passed away recently. He had a common law partner, Suzanne. They were not married, and George and Suzanne lived in Victoriaville, Quebec. The couple had two children, Michael and Lisa, who are 45 and 47 years old. Michael, the son, also lives in Victoriaville. As for Lisa, the daughter, she moved to California, where she has been living for many years. The family has gone through the first steps we just talked about, and now George's affairs need to be settled. The family has received a response after checking for a will. So here are the possible situations. A, George might not have had a will. B, he might have had a will that was not made by a notary. Or C, he might have a notarized will. So let's look at each of these scenarios one by one then. So estate situation one, George did not have a will. So what happens here? Well, in this case, the law determines who inherits. Educaloi does have a tool and article about that, that explains what happens, who inherits when someone dies without a will, but they are both currently unavailable because they are being updated following the change of rules regarding partners in a parental union. They'll soon be available again. I have colleagues who are actively working on that, but for now, you can refer to this webpage that I'm going to put in the chat. This webpage on the government's website that explains all the rules, and we'll look at it together as well. So here you see my screen in the browser. This is called Distribution of the Inheritance in a Legal Succession. So as we can see, the legal succession is when someone dies without a will. And then the surviving spouse that we're talking about, as I mentioned, is either the married spouse or the parental union partner. So here we have the table. I'm just going to make it slightly smaller so we can see a bit more of it. So it does explain exactly, who inherits when. When it's gray, there are no such successors. And then when it's brown, they're excluded because other people are prioritized when we're giving out property. So in our scenario, George has two children. So there are children here. So we're only looking at the first two lines because George has two children. Now, does he have a surviving spouse? As we saw, spouse here means either married spouse or parental union partner, which he does not have. His common law partner, Suzanne, is actually not entitled to anything. It's the first section here. He does not have a surviving spouse, but he has children. So his children or their representatives will inherit everything. So it's the first line here that applies to George's scenario. I'm just going to come back here. So if there is no will, Michael and Lisa, the two children, will need a document which confirms who the heirs of the deceased are according to the law. This document is called the Declaration of Heredity, and some institutions will have their own forms to use to draft the declaration, but if not, a lawyer or a notary can also draft the document for you. And this will be required just so that everyone knows that things were done according to the law before being able to transfer all the property to the heirs. Also, if there is no will naming a liquidator, the heirs must decide together who will be the liquidator of the estate. In this scenario, Michael and Lisa will name someone together. So the liquidator can be one of them, or it could be someone who is not an heir at all. It could even be a professional. So they could pay a notary, a lawyer, or an accountant to act as liquidator if they prefer it. Okay, I just wanted to mention this just because we had the question earlier. So it's best that the person who will settle the estate not to live abroad, because otherwise this could result in tax issues. So in our scenario here, Lisa, the daughter, lives in the United States. So ideally, she would not be the liquidator to avoid these tax issues. So let's move on to estate situation 2. So George had a will that was not made by a notary. So again, here either the holograph will entirely handwritten, signed by the person, or a will made before two witnesses. So a will that is not made by a notary does have to go through a legal process called probate, even if it was made with the help of a lawyer. So as long as it's not made by a notary, there is this probate process that has to happen. So this means that you need to go to court to get a court decision or go to a notary to get the document probated, which means confirming that the will was made by the person who died and it's the last will. So it's the most recent one, and that it also respects all the legal requirements for it to be valid. So there are two ways to probate a will. So again, either you ask the notary to prepare the probate document, or two, you go to the court, you ask the court to have the will probated. So you can submit an application to the court on your own or with the help of a lawyer or notary. But again, in this case, there would be fees. Something to know when choosing, what kind of will you want to make. The probate process can take several months. And if you ask a professional for help with this process, it can be actually more expensive to get the document probated than to make a will before a notary before you actually pass. So the fees you would pay for a notary to make a notarized wills might be lesser than the fee that your heirs would need to pay a notary or the court for the probate process. If the will is made before a notary, it doesn't need to be probated. It is what we call a notarized will, which is situation 3 here. So, estate situation 3, George had a notarized will, which is a will made by a notary. So, you'll need a certified copy of the will to settle the deceased's affairs. If there is a notarized will, you do want a certified copy, which is one that includes the notary's original signature. So it's not a photocopied signature. It's really a copy of the document where the notary still signs directly on the document. You might find a copy of this document with the notary's original signature in the deceased papers. Generally, there are, several copies made when the will is made, and you might leave with a copy. But if you can't find it, then it is possible to request this certified copy from the notary who made the will directly. If you find a more recent will than the one made by the notary, and this more recent will is not made by a notary, then you do have to follow the same steps as if there were no notarized will at all. So situation B that we saw earlier, which is to say you do need to get that most recent will probated. So it's really the most recent will that applies here. So even if there was a notarized will, if you find a more recent will that is a holograph will or a will made before two witnesses, then you do still need to go through the probate process. So this does bring us to the end of this section, which I'm sure a lot of you have questions about, just because the types of wills, which one should I make, why, etc., is a very interesting topic here. On the screen, before we move on to the next question period, there is a handy infographic prepared by Educaloi, which gives an overview of everything we saw so far in the workshop. So as we can see, what to do after someone dies, you want to notify the government to get an official proof of death. You want to organize the funeral following the deceased's last wishes. So, make a search in the registry of funeral prearrangements. Otherwise, do look at, other documents, their own documents, or see if someone else has spoken about this with the deceased. And then carry out a will search. And then, is there a will? Different options depending on yes or no, if it was made by a notary, not by a notary, or there is no will. And then that's when the liquidator will then get involved. So these are all those preliminary steps we talked about. I'm going to copy the link in the chat again, but do note that this link will be sent to you by email again after the workshop. So no need to copy it if you don't want to look at it immediately. So that being said, we are at our next question period right before the break.
Kate, do you have any questions that people have submitted? And if you haven't
Um,
submitted your question, put them in quickly now, please.
I only have a few. We can start off with how do we request a copy of the notarized will if the notary is no longer in practice?
Mhm. So generally, when a notary retires or if they pass away, etc., there is they generally have to write down in their documents to the Chambre des Notaires who would take over their files if ever, they stop practicing or they pass away. So most of the time, it's another notary that will have those documents and that will take over the role basically of the deceased or retired notary. So it would be the other notary that would be able to give you a copy of that original will with their signature just to certify it as a copy. So that's the way that would happen.
And who can request a copy of the notarized will?
So many different people can request a copy of the notarized will. So the first one, obviously, is the liquidator. So if you request it, the notary could make sure in the will to see, well, who's in the liquidator, who are the heirs named as well in the will, because other than the liquidator, the heirs named in the will can request a copy. So they will be able to see what exactly they inherit, what exactly is written in the will. And then also the people who would inherit by law, if there was no will, can request a copy of that notarized will. So if they were allowed by law to inherit, then they have a right to see the will to make sure that, well, they are not going to be inheriting. So those are the three different types of people that can request a will: the liquidator, the heirs named in the will, and the people who would inherit by law if there was no will.
And what are the difficulties with adding a handwritten codicil on a notarized will?
That's a great question. So when there is a handwritten codicil, so a codicil is just a little modification or something that you want to add to your will or change in your will. If it's handwritten, so it's not notarized, then you do have to get the codicil probated as well. So it kind of acts as if it was a separate document. So even if the notarized will normally doesn't need to be probated, if there is a handwritten codicil, then you do need to probate the entire thing in short. So if you do have a notarized will, I would recommend getting a notarized codicil instead, just so that you do skip that whole probate process.
Is it appropriate for someone who's inheriting, such as children, to witness a handwritten will?
So in that case, whether it's appropriate or not, I can't say. Now, legally, if it does go to court, the issue here would be that if a child was in the presence of their parent when they were, say, writing the will, drafting the will, then other people could potentially contest and say, well, clearly it wasn't done out of their own free will. There was maybe pressure involved, etc. So it can be tricky. Now, appropriate or not, I think I'll let everyone decide on their own just because I can't really speak on that. But for example, that's why when you make a notarized will, people who inherit are generally not going to be in the room. They can't be the witnesses, for example, for a official will made before two witnesses. It is something to keep in mind, but it's not for sure that, if there's a child or someone else present that is inheriting, that they will not inherit because they were in the room when a holograph will was being drafted.
And do notaries require a medical competence certificate for someone over 85 before writing their will?
So it's not a legal requirement to have a medical competence certificate. Generally, the notary is formed to still see red flags. So people will come in, the notary will ask questions to make sure they understand what they're doing, they understand why they're there, they understand what they're trying to put in their will. If the notary does see that, things don't quite seem right, or we're not sure if the person who is drafting their will is fully of sound mind, then they could take additional steps to, get either a proof of some kind, but it's not a legal requirement.
Someone just message how to find a notary.
Great question. I was actually going to show this at the end of the workshop. Educaloi's website, so educaloi.qc.ca/yen if you want the English version. Otherwise, you can just click on the button here to switch to English. No matter what page you're on our website, if you scroll all the way down, we have a Get More Help section. If you click on Get More Help, you'll be able to find lawyers and notaries, and you'll have a button, Find a Notary, which leads to the Chambre des Notaires, so the Notaries Association's own search tool. So that's a great place to find a notary. Otherwise, if you want to find a lawyer, that's also a great place to go to find a lawyer. So either free lawyer, low-cost lawyer, or just regular lawyer as well. So different places to get help on this page, this Get More Help page.
From Mary, I have a will. The term liquidator is mentioned. My two children are named, but nowhere is the term heir mentioned. Would they automatically be assumed the heirs?
So even if the term heir is not mentioned, if say, oh, I leave this to X person is written, or like, they are already the heirs. So it's not because the term is not used that legally they aren't heirs. Heirs is, it's a fact. It's less of a thing that you name. It's as long as you leave something to someone, they are an heir. They are inheriting something. Otherwise, if your will doesn't leave anything to anyone, it really just names a liquidator and transfers, say, RRSPs to a spouse, etc., then anything that isn't mentioned, well, it would follow the legal rules. So if you don't write who's going to inherit in your will and you just use it to name a liquidator, give them powers, etc., then it's still going to be the legal rules of succession that will apply.
And is it mandatory for the will and or codicil to be read to all beneficiaries?
That's a good question. I don't believe it is. Um, yeah, I think that's more of a myth with, or either it's American law or it's a myth that we see in movies. But I don't believe the full will and all the codicils need to be read out to anyone who inherits, all the people involved in the will.
The legal rules mean the children are the heirs? Question
So
mark.
the legal rules is the table we saw here. So it could be the children, but most of the time, if there's a surviving spouse, then it would be two-thirds children, one-third spouse. And then again, it depends on who's available. Are there children at all that did the person have children? If they didn't, then we move on to the next line, etc. So very complicated rules, which is why I, again, can't answer and say, yes, it's the children are the heirs. It really depends on the situation, who's available, who's still alive. So again, Educaloi does have a tool that will be back up soon. It's a little quiz type of tool where you just click who is there or who isn't there, and then we would tell you who is legally able to inherit according to the law.
And who exactly gets a copy of the will codicil?
The will codicil is generally part of the will. Normally, people will either staple it with their will that they're currently modifying, especially if, say, you get a codicil done with a notary to modify a notarized will, then it's going to be with the same document. So who exactly gets a copy of the will codicil? So in the case of a notarized codicil, then it would be the same people who can get a notarized will. Otherwise, if it's, in the person's personal papers, it really depends if they have, again, do they need to know the information? Does the liquidator feel comfortable sharing the information? There's no legal rules really on who can ask for a copy. It's more, will the liquidator show it to them or not? If they don't, and the person believes they have the right to see that codicil because they think it concerns their inheritance, or for whatever other reason, they can go to court and ask the court to determine. But it would be up to the liquidator to determine yes or no. Do I want to share it? Do I think it's relevant to this person? So yeah.
And if one adult child is not named as an heir, could there be any legal issues for the other children named as heirs in the will?
Um, it Most of the time, no, just because what is written in the will is generally going to be respected because those are the wishes of the person. Now, the issue would be more if what the child who does not inherit goes to court and says, "Well, why was I not in the will? Is it because there was pressure from the other children?" So again, it's more about that idea of, is the will valid? So was it made when the person was of sound mind? Was there pressure, etc.? So that's a whole can of worms, and things that have to be dealt with in court, depending on what proof is available, what kind of, the testimony of the children, etc. Was there a notary involved as well? If there is a notarized will, then it can be much more difficult to contest, saying that the will is not valid, that the person wasn't of sound mind, just because, again, the notary has a duty and obligation and some kind of training to make sure that the people who write these wills are of sound mind and are able to determine what they want.
Someone else asks, if I leave a special request to someone in my will and then name her as a liquidator, will she have to declare it on her taxes?
The liquidator and the heirs are kind of like separate things. So whatever happens to the heirs, if they inherit something, then yeah, they would declare it in their taxes. The fact that she's liquidator or not doesn't really have an incidence on all of that.